firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
The firm invests in its team and emphasizes professional development. We are keen to share our knowledge and publish our articles on our website. And we also give back with our corporate social responsibility activities. We cultivate a passion for the law and enjoy what we do. This brings out the best in us for our clients today and tomorrow.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome everybody. Thank you for joining us for today's online talk entitled Introduction to Management and Maintenance of Strata Developments. For those of you who are here just now, we hope that you enjoyed our short video. My name is Celinne. I'm a Pupil-in-Chambers with Ma Wing-Kwai & Associates, and I will be your moderator for today's session. Before we start today's talk, let me introduce the firm and what we do. Ma Wing-Kwai & Associates is a mid-sized law firm that was founded in 1985 by Datuk Ma Wing-Kwai. Our able team today comprises of 22 lawyers and a support team of 19. Datuk Ma is today a consultant with the firm, following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with small medium enterprises, SMEs, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, including litigation, adjudication, and arbitration, a dedicated employment industrial relations team, and a department focused on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWKA online talk series. By way of a background, we have been organizing monthly lunch talks at our office since 2013, some of which has been broadcasted live. But with the COVID-19 MCO, we have moved online in order to achieve our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsels. As we have received many positive feedback regarding our online talks, this series will be a continuous effort that we will carry out throughout the CMCO and hopefully in the future as well. This is currently our 18th talk in our online talk series, which has been attended by some 3,800 attendees. Today, we are expecting around 200 people who have registered with us online. Please visit our website at mawingkwai.com for more information, to read our articles, and to sign up for more upcoming talks. Before I continue, please be reminded that this talk does not constitute as legal advice. In the event you require specific legal advice to your matter, please contact us for a complimentary legal consultation. Details will be given at the end of this talk. We have two speakers for today. Allow me to first introduce to you our partner in our dispute resolution department, Mr. Chong Chieh. Mr. Gunn holds a Bachelor's of Law from the University of London and obtained an LLM in International Economic Law in the East China University of Political Science and Law. He was admitted to the Malaysian Bar in 2009. His area of practice includes general litigation, will writing, probate and administration, contentious probate litigation, banking litigation, debt recovery, arbitration, construction, family law, criminal law, and management corporation and joint management body disputes. We also have Mr. John Chan, a senior associate in our dispute resolution and employment department, joining us as a speaker today. Mr. John Chan holds a Bachelor of Laws from University Kebangsaan Malaysia and was admitted to the Malaysian Bar in 2014. He is also an active member in the Bar Council Sports Committee. His areas of practice includes employment law, unfair and constructive dismissal disputes, contractual and commercial disputes, debt recovery, strata management disputes, and director and shareholder disputes. Do note that our speakers will target to complete their presentation by 11:45 and then take questions. If you have any questions, please don't forget to post it up on Slido or in the chat, and we will address them at the end of this talk. You can access the Slido page by just scanning the QR code or going to the Slido website and key in the number 44351. So today, Mr. John Chan will be speaking first on the common duties of and powers of the developer, JMBs, and MCs. And following that would be the duties and powers unique to the developer, JMB, and MC respectively, as well as the general timeline for handing over from the developer to the JMB to the MCs. Whereas Mr. Gan Chong Chieh will then be speaking about how management bodies can recover outstanding maintenance charges. I will then, at the end of this talk, we will then conclude with a Q&A session. I will now hand over to the first speaker, Mr. John Chan, to start the first topic on today's talk.
And it is really impossible to cover everything in my time slot of 20 to 25 minutes. So I will be providing an introduction on the duties of the management bodies, the developer, the JMB, and the MC, which will then overlap with the topic on the transition of management between, or rather from the developer to the JMB to the MC. So I do apologize upfront if I have to go through some of the slides rather quickly later. Right, so on the legislation, there is the Strata Management Act 2013, complemented by the Strata Management Maintenance and Management Regulations 2015, and the Strata Titles Act 1985. Previously, it was the Building and Common Property Maintenance and Management Act 2007, which was repealed on the 1st of June 2015. And on the same day, the SMA and the the SMA came into force, and the Strata Titles Act was amended to complement the SMA. This is the preamble of the SMA. It says that the SMA is an act to provide for the proper maintenance and management of buildings and common property and for related matters. Now I will start with some common duties of the developer, JMB, and the MC, which are provided in these sections 9, 21, and 59. Firstly, to determine and impose the maintenance charges, to determine and impose the sinking fund contributions, to effect insurance on the building, and to comply with any notice or order given by the authorities to repair or do work or improve any part of the common property. This is followed by to prepare and maintain a register of all parcel owners, ensure that the accounts required to be maintained are audited, to enforce bylaws, and to do such other things as may be expedient or necessary for the maintenance and management. And here are some common powers between the developer, JMB, and the MC. Firstly, they have to collect charges and sinking fund contributions. They are authorized, they shall authorize expenditure for the carrying out of maintenance and management. They can recover from any parcel owner any sum expended in compliance with the authority's notice and order, and again to do all things reasonably necessary. These are the common accounting and auditing duties. Firstly, they must prepare accounts and records of accounts which will explain the transactions of the maintenance and sinking fund accounts and enable true and fair balance sheet, income and expenditure statement and profit and loss statement. They must appoint and approve company auditor to carry out the annual audit, and they must file to the Commissioner of Buildings a certified true copy of the audited accounts and auditor's report within 14 days of the accounts being audited. And this is an annual thing. Now I will go into the developer's management period. Section 9 of the SMA states that during the developer's management period, the developer shall be responsible to maintain and manage properly the building. The question arises, when is the developer's management period? Or how long is the developer's management period? Well, the developer's management period commences from the date of delivery of vacant possession. And after vacant possession, the JMB must be established not later than 12 months. And 1 month after the establishment of the JMB is where the developer's management period ends. So a maximum is 13 months, or subject to any extension by the Commissioner of Buildings. I will further show this developer's management period later on in my slides. So the developer's other duties, apart from the common duties which I showed just now, is to ensure that a separate and distinct area is set aside for the admin office. So the admin office must be from common property, and the developer cannot enter into any contract with regards to maintenance and management for any period after the expiration of the developer's management period. The reason for this action, I think, is so that the developer does not enter into any contract which will then go into the JMB's management period when the JMB comes into force 12 months later. The developer must open one maintenance account and one sinking fund account, and this is a strict provision. There shall only be one maintenance account and one sinking fund account, and it shall be opened before the delivery of vacant possession, but in any case before the charges are collected from the purchaser. The developer must deposit into these accounts the charges and the sinking fund contributions, and including developers' own charges and contributions even for their own units which have not been sold. And any collection of monies must be put into the maintenance account within 3 working days. So the developer must not hold it for more than 3 working days after collection. The Act says that the monies in the accounts are held on trust and are not the property of the developer. The maintenance fund can only be used for general and regular expenses, whereas the sinking fund can only be used for capital expenditure. Now comes the duty to convene the first AGM of the JMB within 12 months. Firstly, the developer must give written notice of the first AGM to all purchasers not less than 14 days before the intended AGM. The notice must be displayed at an obvious part in the building. And for the purpose of the AGM, the developer must prepare an annual budget to be voted or to be considered at the AGM. This annual budget is to properly maintain and manage the building for the next 12 months after the first AGM for the JMB. Now this is the mandatory agenda as provided in the SMA. During the first AGM, the JMB shall determine the number of members of the Joint Management Committee and to elect those members into the JMC. As I said earlier, they must consider the annual budget prepared by the developer, also to vote and determine the amount of maintenance charges and sinking fund contributions to be paid by every parcel owner, and also to determine the late payment interest. The JMB at the first AGM must also consider the audited accounts of the developer to confirm the taking over of the insurances effected by the developer. The JMB can make additional bylaws and consider any other matter connected with the maintenance and management. Right, so after the AGM, within 1 month after the AGM, the developer shall hand over to the JMB all monies in the maintenance and sinking fund accounts, at the admin office, the audited accounts, all assets in the building, and all records and documents necessary for the maintenance and management of the building and the maintenance and sinking fund accounts. Further, the developer must also provide a copy of all the approved plans, documents that indicate the location of the pipes, wires, cables, and other parts of the building, all contracts entered into by the developer regarding the maintenance and management of the building, and the schedule of parcels filed with the COB, and the proposed strata plan filed with the land office. The developer must also provide the names and addresses of contractors and subcontractors during the construction of the building, documents including warranties, manuals, and schematic drawings of the common property, a register of all parcel owners of the building, and an original copy of the insurance policies effected by the developer. Now the JMB has been established. The JMB is a body corporate, meaning it's to be treated as a corporate entity or a company. It can sue and be sued, and the JMB comprises of all purchasers and the developer. Section 20 imposes a duty on the JMB to inform and register with the COB its name, its official name, within 30 days after the AGM. The Act says that the JMB must properly maintain and manage the building and keep it in a state of good and serviceable repair. Then there are the common duties, which I've explained at the start. Almost similar to the developer's duty is that the JMB shall not enter into any contract relating to maintenance and management for any period exceeding 12 months. So any contract entered by the JMB for maintenance and management can only be a period of 12 months. The reason for this is because at any time the strata titles may be issued, and this will trigger the establishment of the MC. So if the JMB had entered into, just say, a 5-year contract, then the MC, there will be complications when the MC is established and comes into being, and then it has to consider that 5-year contract entered into by the JMB. So yeah, 12 months. Similarly, the JMB must open and maintain one maintenance account, and this maintenance account will include the balances which was transferred from the developer, the maintenance charges collected by the JMB, all monies from leasing, renting, and use of any property charged by the JMB, and monies and property including vesting, interest, donation, and trust. Maintenance account can only be used solely for the purposes of meeting the actual and expected general regular expenditure necessary. Similarly, the JMB must open one sinking fund account, and it will include the balance from the developer and all contributions collected from the parcel owners. And the sinking fund monies can only be used for capital expenditure. Now, apart from the common powers, the JMB also now has power to purchase, hire, or acquire movable property for use of the parcel owners in connection with the common property. The JMB can also employ or arrange and secure services of any person or agent to undertake the maintenance and management of the common property. Now, at the AGM, or at every AGM, the JMB shall elect a JMC, and the JMC can exercise powers of the JMB on behalf of the JMB. And the JMC shall also include one representative from the developer. So the second schedule of the SMA states that the JMC must have a minimum of 3 members and a maximum of 14 members elected at the AGM. The reason for a minimum of 3 is because there should be a chairman, secretary, and treasurer, which are elected among the members. So the AGM will elect the number of members in the JMC, and after the AGM, those elected members will elect among themselves who will be chairman, who will be secretary, and who will be the treasurer. And these members retire automatically after the conclusion of next year's AGM. Now, what happens when strata titles are issued? So once strata titles are issued by the land office will also open the strata register, and with that, the management corporation automatically comes into existence on that same date. Accordingly, the land office will issue a certificate of establishment of the MC to the developer, if I believe correctly. So after the issuance of strata titles, which will be in the developer's name, the developer will then commence perfection of transfer of the strata titles to each purchasers of each strata title. So this takes time usually. So then the question of the initial period comes in, where the Act defines it in this very long definition. But in simple terms, the initial period is a period between the establishment of the MC until there are parcel owners having a total of 25% aggregate share units. So this 25% aggregate share unit means that after the developer has transferred a total of 25% aggregate share units to by way of the perfection of transfer to the parcel owners, then the initial period will end. And why this initial period is significant is because the Act says that at the 1 month after the expiration of the initial period, the developer must convene the first AGM of the MC. So if I may recap, there is the strata titles issued, opening of the strata register, the MC is established, and the initial period starts. So in that period, the developer will transfer its titles, the strata titles, to the parcel owners. And once, because of the transfers, when 25% of the aggregate share units is achieved, the initial period ends, and 1 month after that, or within that 1 month, the developer must convene the first AGM. Similarly, the developer has the duty to give written notice of not less than 14 days. An annual budget of the next 12 months must be prepared by the developer for the first AGM. The agenda of the first AGM of the MC is quite similar to the JMB. It must determine the management committee and elect the members, consider the annual budget, decide to confirm or vary the amount of maintenance charges and sinking fund contributions, determine the late payment interest, consider the audited accounts, decide to confirm, vary or extend any insurances affected by the developer, or in this case, it should be the JMB, and to make additional bylaws. And so within 1 month after the first AGM of the MC, the JMB shall hand over to the MC the monies in the maintenance and sinking fund accounts, any additional bylaws, audited accounts of the maintenance and sinking fund accounts, all assets and liabilities of the JMB, the documents that were delivered by the developer, and the records relating to the maintenance and management. And the Act also provides expressly that the JMB dissolves 3 months from the first AGM of the MC. So the management corporation is now with hands and legs, meaning the management committee. It is similarly a body corporate. It can sue and be sued. It comprises of all parcel proprietors. There is no mandatory provision for the JMB to be part of the MC. It must be voted in. And the MC is the express proprietor or owner of all common property in the building. So these are the MC's duties. Apart from the common duties, it must also prepare and maintain a strata roll of the building. It has similar duties with the JMB, which is to open and maintain one maintenance account, which can be used for general and regular expenditure. And it must also open one sinking fund account, which can only be used for capital expenditure. The MC's powers, if you see here, 2, 3, and 4 are similar to the JMB, but the powers unique to the MC is that it can now borrow monies required by the MC, and it can secure repayment of monies by instrument or charges. This is the management committee, which is similar to the JMC of the JMB, and these provisions are also the same as per the JMC for the JMB. Now, the general timeline, which I want to show all of you. Right, this is the general timeline chart, which Mawing Kwai and Associates has come up with. So if you can see my cursor, on the left, the developer's management period starts with the vacant possession, delivery of vacant possession. And within 12 months, it must convene the first AGM of the JMB, which is also the establishment of the JMB. Within 1 month after the first AGM of the JMC, the developer must complete the handover to the JMB. And it is after this date, which is the expiry of the developer's management period. So after this, there is really no conclusive date of when the strata titles will be issued, which will trigger the opening of strata register and establishment of the MC. So this may take 1 year or 5 months or 5 years, some even 10 years. So once strata titles are issued, which triggers the opening of the strata register and establishment of the MC, for example, here in the middle. Then the initial period starts, where the developer transfers the strata titles to the owners. And once at least 25% is achieved, within 1 month after that, the developer must convene the first AGM of the MC. And 1 month after the first AGM of the MC, the JMB hands over to the MC. And 2 months later, the JMB is automatically dissolved by the SMA. And the MC continues to run perpetually. Now, what happens if the strata titles are issued during the developer's management period within this 12 months? So if the strata titles are issued, triggering the opening of the strata register and establishment of the MC during the developer's management period, the Act calls that period now the developer's preliminary management period. So before the 12 months where the JMB must be established, if MC is established, then it triggers the initial period here. And once 25% is achieved, within 1 month after that, the first AGM of the MC must be convened by the developer. And 1 month after that, the handover from developer to MC. So in this scenario, there is no JMB coming or being established. Okay, that concludes my part. I will now hand over the presentation to my colleague, Gan.
Hi, thank you, John. Thank you everyone for attending today's talk. I will continue today's talk with this topic, how to recover outstanding maintenance charges. So the question that will come to most of the JMB or even the MC's mind will be, how do you all recover the outstanding maintenance charges from the owners? The usual way or the procedure would usually be after issuing the statement of accounts, and let's say the owners still fail to pay any of the maintenance charges, then according to para 6.3 of the third schedule of the Strata Management Regulations, one way is you can publish the names of the defaulters. And I believe for most of the participants here, maybe that's living in condos or even apartments, you usually you can see that names are published in the lift or even at the common area where the notice boards are. So that's one way to actually put pressure on the defaulters to actually come out and make payments. The next way is this is provided for under the Strata Management Act and also in the regulations to issue the notice of demand. Form 11 is for JMB and Form 20 is for the MC. So after the issuance of the statement of accounts and the defaulters still don't come forward to actually make payments, then you can issue a notice of demand. So upon issuing notice of demand, and in the notice of demand, the timeline given is 2 weeks or 14 days for them to make payment. So only upon the expiry of the 14 days, then the MC or even the JMB can then proceed with the restricting access or the activation of the access card. This is provided for under para 6.4 of the third schedule of the regulations. Can also restrict access, use of common facilities, which is provided for also under the regulations. Alternatively, the MC or the JMB can actually enter into an installment payment scheme with the defaulters. Perhaps that could also be a way where defaulters could make a monthly payment. At least the JMB or even the MC could recover something rather than nothing. The other way, or most people that may think of, is to get a lawyer to actually issue a letter of demand. This is a very common prior to the coming of the effect of the Strata Management Act. Lawyers can actually will issue demand. Perhaps by doing that with a lawyer letter, defaulters are more willing to come out and then to pay for the maintenance charges. Under Section 35 and Section 79 of the Strata Management Act, there's this new provision on warrant of attachment, which is issued by the Commissioner of Buildings. So after issuing the demand and after the 14 period has lapsed, still no payments that is forthcoming, the MC or even the JMB can apply to the Commissioner of Buildings for the Commission of Buildings or COB to issue a warrant of attachment. So this warrant of attachment is to attach movable properties belonging to the defaulters. So what will transpire is once the warrant attachment is given or issued, then the MC or the JMB or any of the committee members can use this warrant attachment, go to the unit, and then get into the unit to actually attach the properties inside, the movable properties inside. So the question that may come to in our mind will be, can we actually force to go in? According to the Act, the word used is forcibly enter. So there is still no case law per se on how do you actually get into, can you use by force? But if let's say there's any difficulties in executing the warrant of attachment, then the Commission for Buildings can actually provide policemen to actually assist the MC. So after the warrant of attachment, let's say the MC or the JMB managed to attach some of the properties, the movable properties. If it's perishable, then you have to sell. If not, those other things you have to keep it, and then there's a timeline to actually then still allow the defaulter to come and pay. If still no payment, then you can actually auction it off. So the procedure is quite thorough, and if any of the MC or JMBs or even any of the participants would be interested to explore this avenue, then perhaps we are available to discuss this further and to actually go through the process. The next way to recover outstanding maintenance charges will be to file a claim in the Strata Management Tribunal. The Strata Management Tribunal is something like a court. The austerity and the conduct of like a court is there. So or something even like the labor's court per se, yeah. So you can file a claim there, and there are forms that's provided for in the Act where you don't need legal representation. The MC or even the JMB can actually then put in the forms to actually claim against the defaulters. The next way is to file a civil suit in court. So before even proceeding to file a civil suit in court, the MC or even the JMB is advised to actually exhaust the procedure that is provided for under the SMA and even the regulations, which is to issue the notice of demand. So there is a need to issue a notice of demand, and upon the expiry of the demand, then the MC or even the JMB can consider filing a suit in court. Another way or another alternative, without going through all this legal process, which the MC or even the JMB could explore, would be to report to CTOS. This is where the MC or the JMB could provide CTOS with the information of the defaulters and how much they have been defaulting, and then CTOS would then actually put it up in their report. So, and this one way is it's beneficial to the MC or JMB is because let's say, for example, if the defaulters intend to get a loan from the bank and the bank managed to capture that this particular defaulter has a CTOS report on him or her, then the bank may not actually get the loan or release the loan or grant the loan. So this is an alternative method. So filing a claim at the Strata Management Tribunal or court. So this chart lays out the procedure. So the parcel owner defaults in the payment of maintenance charges. If it's the JMB, then they will serve Form 11, the notice of demand. If it's MC, then Form 20. If the defaulter fails to comply with the payment, the demand, then there are two options here. One could be to make a complaint to the Commission of Buildings, and the Commission of Buildings can actually prosecute the defaulter. But so far, I personally have not seen a prosecution on this part, whereby the defaulter will be liable to a fine of less than 5,000 or an imprisonment less than 3 years. If there's a continuing offense, meaning you still don't pay, then there will be a further fine below 50 for every day. Or subsequently, the management bodies can apply for warrant of attachment or file a tribunal claim or civil suit, which I just explained earlier. So I believe many of the participants will have heard of all these methods whereby if the defaulters fail to make any payments, then they would clamp the water supply, cut off the electricity, restrict access into the parcel, don't let them to park at their car park bay. And all these are considered illegal methods. And this has been decided in the John Dennis de Silva's matter, which I will then explain later. Before I go into the John Silva's matter, let me just, this is a pretty recent case on Mok Xiao Min against Hampshire Residents Management Corporation. It's a 2018 case. Here, the plaintiff commenced a suit against the MC and the council members for nuisance and primarily for the deactivation of the access card for the plaintiff units at Hampshire's condominium. The MC contends that the deactivation of the plaintiff unit access card was due to the outstanding maintenance charges and sinking fund payments by the plaintiff, and it was therefore lawful. This is what the MC has contended. The MC also asked the plaintiff tenants to pay the rent for the units directly to the MC. So meaning the MC went knocking at the units and directly asked the tenants to pay the rent to the MC. However, in this case, the MC failed to issue the required notice under the Strata Management Act and also the regulations to demand payment from the plaintiff. So what did the court held? The court held that the deactivation of the access cards for the plaintiff units are not in accordance with the Act and regulations and is therefore unlawful. The conduct of the MC in asking the plaintiff's tenants to pay the rent directly to the MC has caused nuisance and damage to the plaintiff. And the reason why the High Court held that the deactivation of the access card was unlawful or not lawful is because the MC failed to issue the required notice or the statutory notice under the Strata Management Act. Hence, since the MC didn't comply or follow the procedure provided for under the Act, therefore the deactivation of the access card is deemed unlawful. And in this case, the court awarded damages to the plaintiff, which is Mok Xiao Min. Okay, the next case that I would like to share with the participants will be John Dennis de Silva against Crescent Court Management Corporation. This case was decided during the Strata titles regime. And in this case, the plaintiff did not pay his monthly maintenance charges, and the MC prevented the plaintiff from entering the car park bay. The MC also claimed the water supply since the plaintiff did not pay for his water charges. The plaintiff then applied for an injunction against the MC. So basically, the plaintiff now wants to injunct the MC from letting him to get into his car and to ask the MC to not to claim the water supply. So in this case, in the High Court, the MC contends that it will suffer great injustice if the plaintiff injunction is allowed, because it will create a class of person who could openly declare that they will not be paying the monthly maintenance charges, yet entitled to all the benefits of the common area. The MC also contended that since the plaintiff did not purchase the car park bay, so in this case, it's not an accessory parcel. It was a car park bay which was assigned to the plaintiff upon delivering of the vacant possession. So it was the MC contended that it was only allocated to the plaintiff, and therefore the MC has the right to relocate if it so desires. So the High Court then in this case held that there was no concrete attempt to comply with the Strata Titles Act 1985 in recovering the monies due to the MC. The unilateral act of preventing entry based on monies owed to the MC contravenes the provision of the Strata Titles Act, which sets out the recourse available for recovery of sum as debt. So in this case, the court held that the MC should have followed the remedy provided for under the Strata Titles Act, which you can issue your notices and then to file the necessary claim to claim for the claim as a debt, instead of preventing the owner from using the car park bay and also to clamp the water supply. The court further held that because the plaintiff is an holder of an indefeasible title to his unit, as such, he should have given the right to access to his unit and without fear that his water supply would be clamped. And the plaintiff also has proprietary interest in the car park bay because the car park bay was assigned to the plaintiff since 1979, and he has paid for the construction of the roof above the car park bay. Hence, the clamping of water supply is an illegal method, so it's not something that we will advise our clients to do. So before any of the MC or JMB go on to this route to actually to clamp or cut off water electricity, have to consider this case in mind. Right. In this case, the court also found that the remedy was to file a claim for the recovery because its money is due. So you cannot actually prevent the owner or the plaintiff from actually going back to his house. Right. That's the end of my session on recovery of maintenance charges. I will pass the floor back to Celinne, and we will then take questions from the floor.
Okay, hi everyone, thank you for staying with us. For those who have missed out on a QR code before, you can go to slido.com and key in the number 44351. And we have now reached our Q&A session, and we will now take questions from the participants. So for the first question, during the CMCO period, can the JMB seek owners' consensus on reduction of service charges for short-term by postal decision? Is this legal? John?
Celinne.
Okay.
Thank you, Celinne. Well, during this MCO or CMCO, the Act does not provide for postal decision in any circumstance, whether it's MCO or on a normal circumstance. So to answer this question straight away, no, you cannot do it by postal decision. It has to be by way of a general meeting, which can only be done after the CMCO is lifted.
Gan, anything to add?
No, John's answer is sufficient.
Okay, all right. On to the second question. During the lockdown period, can the GMB or the MC decide on the waiver of late payment interest as the owners are not able to make payment? Some of the owners are not as IT savvy.
Yeah, thanks, Celinne. I can take this question again. I think it's also related to the first question earlier. The courts have consistently decided that the JMC and MC, being creatures of statute, can only do what is expressly provided in the Act. And unfortunately, the Act does not provide that the JMC or MC can waive late payment interest or waive or reduce maintenance charges just like that. So this is because if you look at the Act, the JMB and MC determines late payment interest and determines maintenance charges during the general meeting. And after the general meeting, the JMB and MC must publish Form 5A, if I'm not mistaken, to give notice of all proprietors what the late payment interest and maintenance charges and sinking fund contributions are. So after that, even if there's a lockdown or MCO, the JMB and MC still needs to go back to the general meeting to vote again, to even before voting, to consider and to suggest a new budget for the remaining months of that year, and to show how savings have been made or how additional expenses were incurred for cleaning, for example. And then the attendees of the attendees of the general meeting must then vote whether to reduce the maintenance charges rate for that year and whether to reduce the late payment interest. But coming back to this question, if the question is whether the JMB and MC can decide now on its own, unfortunately the answer is no. It must be by way of general meeting.
All right, thank you, John. Okay, next question. We are having a hard time to collect the maintenance fees as some of the owners are untraceable. So I assume that Miss Julia Ko, she's trying to ask how
Yes.
do you Move on. Yep.
Yeah.
All right.
I think everyone may, or most of the MCs or JMBs may have some hard time to collect maintenance fee, and also their owners are unreachable or untraceable. Unless the MC or the JMB has sufficient fund to actually engage a PI to track them down, which I think most, they wouldn't do it, then the only way is to send your notices to the last known address. Or you can do an IC search and then to send the notices to those addresses that you managed to find from the search. And then from there, you can commence the proceedings. And again, also another way is to put it up in CTOS. And let's say if proceed to court proceedings, then we can actually apply, or the MC or JMB can actually apply for substituted service by maybe putting up in the newspaper, or even displaying the notice in front of the door, which constitute a good service. So there must be some form of action taken to actually to recover, even though the owners are unreachable or untraceable.
All right, thank you, Gan. Okay, and the next question is, what are the type of enforcement options on an owner who has a noisy pet and refuses to remove it, and notice has been issued and sent to the Commissioner of Buildings? Yep, John, thank you.
So the bylaws as it is prohibits animals in the building. So if you're asking what type of enforcement options, firstly, the law provides the JMB or MC the power to issue a fine to the owner. And this fine cannot be more than 200 ringgit. Additionally, if a person complains and then the management gives notice to the owner, the parcel owner has 3 days to remove the pet. If the owner does not comply with this notice, then the management can actually take all steps necessary, which I read it to include breaking into the unit to remove the animal. That's what the law actually says. And all costs incurred for that breaking in and enforcement can be charged back to the owner. And let's see. Yeah, that's it. So the management can actually break into the parcel unit to remove that animal.
All right, thank you, Mr. John. Okay, for the next question, what happens if there are not enough owners with strata titles to form the MC? John, would you like to take this one again?
Yeah, sure, thanks, Lee. Okay. What happens if there are not enough owners with strata titles? Well, then the JMB continues to manage until the 25% aggregate share units is achieved. So yeah, there is no limit to the initial period that we speak about earlier. So that's why some strata schemes can also the transition to the MC can take so long because there is a delay in either the issuance of strata titles from the land office or the transfer between developer to the parcel owners.
Okay, all right. Okay, this has a few parts, but I think I'll take this question first. May I know, can owner request compensation for late handover from developer due to MCO? Gan, would you like to take this question?
Whether can owner request compensation for late handover from developer due to MCO? I think this very much depends on the contract between the parties, whether is there any force majeure clause and other clauses which will be related. But if there is an MCO and let's say the developer couldn't actually proceed with the construction per se, then it's my personal opinion, I don't think that you can actually request for compensation for the late handover. John, do you have anything to add?
Yeah, but that's regarding transfer of titles, right? but the question here uses the word late handover. Maybe it also means a handover from developer to the JMB. But yeah, the Act does not provide for any compensation to be paid if there's a handover, late handover from developer to the JMB.
All right, thanks, Gan and John. Okay, now we'll be going to this 4-part question. Okay, so the property was handed over in 2002, but up until the developer is in charge of the maintenance charges and no formation of GMB by the developer. My questions are, do the developer have any rights under the SMA 2013, the Strata Management Act 2013, to demand and issue notice to collect arrears of maintenance charges because no GMB was established yet? And is there any limitation period for collection of arrears or maintenance charges? And what are the consequences of not forming the GMB within the time? So I think this is a few parts question. John, would you like to take the...
Thank you. Let's see, the question starts from rights under the SMA to demand and issue notice to collect arrears. Yes, as Gan has presented earlier, the developer is included in the statutory forms to collect the outstanding maintenance charges, and then the developer can file a tribunal claim or file a civil suit in court to claim those outstanding maintenance charges. Yes, the developer has that right.
Okay, and then is there any limitation period for collection of arrears of maintenance charges?
So for limitation, no, the court in, I believe, Equity Settegak, the case of Equity Settegak has held that there is no limitation period for the claim for outstanding maintenance charges because it is on a running account. So no limitation there.
Okay, and what are the consequences of not forming the GMB within time?
Not forming the GMB within time. Well, I believe if the developer does not get the extension from the COB, the Act says that it is the failure to convene the AGM of the JMB is a criminal offence. I think a fine of not more than 250,000 and imprisonment not more than 3 years or both.
All right, I'd just like to add to John's answer. So the COB can actually prosecute the developer for not forming the GMB. So basically,
okay.
the law actually allows the COB to prosecute.
Okay. Because of the time constraints, it's already 11:59. We will be taking maybe 1 or 2 more questions. Is that okay, John and Gan?
Yes.
Yeah, sure.
Yeah. Okay. So hi, if no GMB established and the developer is in charge of the maintenance, do developer have rights under the SMA 2013 to collect arrears of maintenance charges? I think this was already.
Yeah, this question was
This was already answered. Okay, so we can skip this one. Okay, so we'll take 1 more question, which is, what is the strata role? This is asked by Julia.
So that is, I can take this question. Right, so the strata role, let me just look at the Act. The strata role is defined in section 72 of the SMA. And so, right, this is the definition. The strata role must contain the following particulars: the share units of each parcel, the floor area of each parcel, the name and address of every proprietor, and name and address of the solicitor acting for the proprietor in the sale and purchase of the parcel, if any. So this is the definition provided by the Act on the meaning of strata role.
All right, thanks, John. Well, we have concluded our Q&A session. Thanks for staying with us so far. We have around 70 questions. That is a lot. And we hope that we have managed to answer your questions well.
Celinne, may I just for the questions that we are not able to answer, the participants can actually then email it to us, which I think Celinne will share the link later. Yes, then we will take it up from there.
If I may also jump in, I think I saw a question that came in very recently, but it's quite far down the queue. It's regarding the Federal Court's decision on the case of JMB Menara Rajawali. So that case was decided yesterday. and the JMB's application for leave to appeal to the federal court against the Court of Appeal's decision was dismissed. So the Court of Appeal decision, I think last October, remains good law and is binding. And that decision is that JMB and MC can only determine one single rate of maintenance charges for all types of parcels. Thanks, Celinne.
All right, thank you, John. Okay, so thank you, Mr. Gan and Mr. John Chan again for your insights. Just note that for Mr. Gan's topic on how to collect maintenance charges, we do have an article up on Mawing Kwai and Associates, our website. So I've already posted it in our link, and you're feel free to check it out if you have missed on our topics. So before we conclude, I have a few announcements to make. Please join us for our upcoming talks. You can scan this QR code on our web or go to our website for more information. So our next talk will be on the 1st of June. It will be on the corporate liability provision under Section 17A of the Malaysian Anti-Corruption Act 2009, which will be done by Ms. Cassandra Nicole Tomasio and Mr. Tommy Wong. They're both from the corporate department in Mawing Associates. And on the 17th of June, do join us again for a talk on interior design and the law, which will be done by Ms. Christine To, who's a partner in our dispute resolution department. And we also have a guest speaker, Mr. Edmund. The QR code is down there and you can sign up on our link. Okay. And please do fill in our feedback form and tell us what you thought about our talk. The link to our feedback form will be posted in the chat. And also do follow or like our social media accounts for more legal updates. We are basically on every single social media platform. So yeah, do follow and like. Thank you. And fourthly, if you like to speak with our lawyers, we do offer a complimentary 30-minute video consultation over the telephone or over video conference. Please fill in the form in our website, and the link is also posted in our chat box, or you can alternatively just scan the QR code on this slide. To our guests, thank you for joining us and staying throughout the session. We hope that you have found today's session informative and useful.